Good morning. Can you see me?
Yes, I can.
Well, I can see you, and you can obviously hear me. Now, I understand that since you retired as being a professor, you prefer not to use the title professor. That's right, I think, isn't it?
I don't think I'm entitled to call myself, but I don't. So, no.
So you don't. So we'll call you Mr. Mildred if we have to use any.
Yes, please do.
Very well. Now, can I explain to you, Mr. Mildred, where we are and who is listening? But first, you can tell us. You're at home, are you?
I am, yeah.
And I gather that there's somebody else there who may come in with a cup of coffee as and when required.
I don't think so, but there's somebody else here, but I think doing something different.
Right.
In a different room.
I've been misinformed. But in any event, when we have a break, you can talk to that person about anything you like, but not about the evidence that you've given or may yet give. It's the familiar
Yes.
thing which judges say, and it is the rule. Now, you are talking, first of all, to this room here, Fleetbank House, where, although we have enough space in non-virus times to have a couple of hundred people, we have 8, all suitably masked up, except for Miss Scott, who will be asking you the questions. Mary will come and ask you to affirm in a moment or two. And the other name you may hear is Shumik, whose job it is to show you any particular documents that Ms. Scott wants to refer you to.
Yes.
But the real audience is that beyond this room, watching remotely, for obvious reasons. There will be, yesterday there were about 250 watching. It'll vary from time to time during the day, but that's roughly the size of the audience who are interested to know what you have to say.
Yes.
So those are the people you're talking to. Now, Mary will ask you to take the oath.
Please state your full name.
Mark Mildred.
And repeat after me. I do solemnly, sincerely.
I do solemnly, sincerely.
And truly declare and affirm.
And truly declare and affirm.
That the evidence I shall give.
The evidence I shall give.
Shall be the truth.
Shall be the truth.
The whole truth.
The whole truth.
And nothing but the truth.
Nothing but the truth.
Mr. Mildred, can you see and hear me?
I can, thank you.
You were the chair of the Skipton Appeal Panel from 2006 until its final meeting in July 2017, is that correct?
Yes.
And you have set out your background and experience and qualifications in your witness statement, and you tell us that you were admitted as a solicitor in 1975 and you worked in private practice, specialising in liability for defective products and in class actions. And during that time, you published a large volume of work on the subject and lectured. Is that correct?
Yes.
And you also tell us in your statement that during your career as a solicitor in private practice, you were a leading member of the team advising the claimants in the HIV haemophilia litigation from 1988 and remained involved in that litigation through to settlement and the establishment of the Macfarlane Trust in 1991. Is that also correct?
Yes.
And you also tell us that you gave some informal advice to the claimants' legal teams in the hepatitis C litigation and in the VCJD litigation. Is that correct?
Yes.
Just to make it clear to you, Mr. Mildred, and to those listening at home, that I'm not going to ask you any questions today about the work that you did in that litigation, but that will be the focus of a further request to you for a further witness statement in due course.
Yes.
You then tell us that you left full-time private practice in 1995 on your appointment as Professor of Litigation at Nottingham Law School, although you continued as a part-time consultant in complex litigation cases throughout your time as a professor. Is that right?
Yes.
And you've also worked in part-time tribunal judicial roles, including for the Family Health Services Appeal Authority. And you've held non-executive directorships in the NHS, including at the time you were appointed to Skipton, being the Department of Health non-executive director of Wandsworth Primary Care Trust. Is that correct?
Yes. It's fair to say that as time went on, the academic work and consultancy work diminished and the judicial work increased. So by the time I retired, I was doing almost nothing but first-year tribunal work.
Now, you came across an advert for the Skipton Appeal Panel, you think in the summer of 2006 in the Law Society Gazette. What drew you to apply for the post?
Well, it was a subject that I knew a little bit about. It was an area of law that I had some experience in, and I was, I think the expression is portfolio work at that stage. I was doing different things. I had no full-time job. So this was something which I thought would be interesting to do, and I might be able to do to a reasonable standard, so I applied.
And you presumably knew a little bit about, as you say, must have known rather more than that about the circumstances in which patients have become infected with HIV and hepatitis C as a result of your work in the litigation that we mentioned earlier.
I did, although hepatitis C played only a small part in that. Most of what I knew was about HIV, but I did know a little bit about it. I'd also acted for the claimants in the Gamma Guard case, which was, well, we might even come on to later. It was a immunoglobulin that caused hepatitis.
You were interviewed for the post by the NHS Appointments Commission and appointed chair of the appeal panel in September 2006, is that right?
Yes.
And after the Skipton appeal panel came to an end, did you have anything to do with the new schemes, the English Infected Blood Support schemes, or their equivalents in the devolved administrations?
No, in fact, before I knew that was happening, I had suggested that by then I'd been in post about 10 years, and I thought that there was a public interest in roles being rotated and committees being renewed. So I thought it was time for me to go in any event.
You also tell us in your statement that the other members of the panel who were appointed at the same time as you were Annie Hitchman, who was the lay member,
Yes.
The hepatologist, Dr. then Professor Mutimer,
Yeah.
Dr. Patricia Hewitt, who is a consultant in transfusion microbiology, and the GP, Dr. Drakas. Is that correct? Drakas. Thank you. And that in 2009, Dr. Drakas retired and was replaced by Dr. Gawley. Is that right?
Yes.
And in 2012, Professor Mutimer was retired and was replaced by Professor Peter Mills.
Yes.
And you tell us that on your appointment, you met with Mr. Fish of the Skipton Fund, who provided the secretariat to the appeal panel. Is that right?
Yes.
And at that initial meeting, you were provided with a copy of the two different application forms. So that's the application form for stage 1 payment and the application form for the stage 2 payment. And you were also provided a document that you'd in fact already seen because it had been sent to you in the application pack for the appointment as the chair. And we'll look at that in a moment. And you think you were also provided at that meeting with a copy of the agency agreement between the Department of Health and the Skipton Fund, although that document may have come to you later. Is that right?
I certainly couldn't have been because it hadn't been signed at that stage. I got it sometime later because, as has been pointed out, it was not signed until a long time after the fund was set up and a year or so, I think, after the panel was set up.
Can we look first of all at the agency agreement, although you didn't have it initially? It's Shomik, it's SKIP 5033 _ 058. You can see there it's an agreement between the Secretary of State for Health and the Skipton Fund Limited, and this may sound an obvious question, but it's right, isn't it, that neither you nor anyone else from the appeal panel were a party to this agreement?
No. Sorry, it is right, yes.
Yeah. Can we go to page 14 of the agreement, please, Shomik? And we'll see at paragraph 6.3, clause 6.3 there, DH, Department of Health, shall as soon as possible after the commencement date arrange for the provision of an independent appeal panel to adjudicate on claims rejected by Skipton. And then if we can turn on to page 31, please. Part 4, appeals, 4.1, an independent appeals panel having been provided in accordance with clause 6.3, Skipton will provide the Secretariat and organise all necessary meetings of the panel, prepare cases to be considered, record the panel's decisions and communicate the decisions to each appellant, and then Skipton will pay panel members fees and expenses. Is this how it worked in practice?
Well, almost. I'm sure we'll come on to the writing of decisions, but it says there that the fund will record the decisions and communicate them. It was agreed with the fund, well, with Nick Fish, that I would write the decision letter, send it to the Skipton Fund, and he would send it out to each appellant. So it's almost right, but not quite right. But.
And then we looked, when Mr. Fish gave evidence, at the parts of this agreement that set out the definition of qualifying persons, and I'm not going to take you to those, but was a copy of this agreement made available to other members of the panel other than yourself?
I don't know.
So you didn't make this agreement available to them yourself, but the Skipton Fund may have done.
Just one question on the process, which is set out at 4.1, and it really relates to what's on the first page of the document. So if we can go back to 3305 _ 058. First page, please, Shomik. No, before that. It's the bit in brackets at the top. Incorporating amendments agreed between the parties on 30th of April 2012. First question really to you, Miss Scott. Is there anything on the face of this document which shows what those amendments were?
From memory, sir, no, I can't recall that. I'm just having a look through to see if there's any text in underlining or brackets, and I can't see that there is.
One of the questions really is, as a matter of course, you'd adopted the process of writing up your own decisions, so you are going back, if we can, please, to where we were at paragraph 4.1.
Page 31.
Do you know why that itself wasn't amended in 2012?
No, I have no idea. I mean, the only copy of this agreement that I ever saw was the one which must have been given to me shortly after it was first signed, which I think is 2007 from memory. I had no idea about the series of amendments that happened after that. I knew about changes in eligibility, either because they were communicated by Nick Fish or else because they were in the public domain, but I didn't see the text of the document changing as it was
amended. So you were sitting in appeal on decisions made under a scheme which, although you understood the basic idea, you hadn't seen the actual wording at that later stage.
I hadn't seen, I didn't see future copies of the agreement itself, but the things which mattered to us were the eligibility criteria, and if they were changed, those changes came to our attention.
Thank you very much.
I don't think anything else in the agreement which relates to the appeal procedure was changed. I may be wrong, I stand to be corrected, but I don't recall anything about our process being changed.
Thank you.
Can we turn, Shumik, then to SKIP 5031 _ 229? Is this the document that you were provided as part of the appointment process and then provided with again by Mr. Fish at that first meeting?
Well, I remember having it to make my application, so I knew what the constraints on or what the scheme was for the appeals. If Nick says that he gave me a copy when we met, then I'm sure he's right. I don't remember that.
In fact, that information came from your witness statement. So, but you
well, I know I met him after I was appointed. I must have had this document to make my application in the first place. If I said in my witness statement that he gave me another copy, that seems to me curious, but if I said it, I must have believed it when I wrote that.
If we go to page 3 of this document, we can see it sets out the role, the terms of reference and the constitution of the appeals panel.
I'm sorry, Ms. Scott, but I don't know if anything turns on this, but I'm just having a very quick look at paragraph 9 of my witness statement, and I can't see that I said I got another copy of the application form. I may be wrong, but...
And perhaps it's my misreading of your witness statement. I don't.
In any event, I saw that application form when I made my application.
I understand. Okay. Yes. I obviously misread your witness statement. I don't think anything turns on it. So can we, if we turn to page 3, we can see there it sets out what the role of the Skipton Appeals Panel, and that's really set out in that end of the third paragraph. The role is because there is a right to appeal to the Independent Appeal Panel against the decision of the Skipton Fund, and then it sets out the terms of reference. The role of the appeals panel is to reconsider cases of any claimant who appeal against individual decisions made by the Skipton Fund. The panel will look at how the decision was reached and examine all of available evidence or seek further written evidence where necessary. And then it says, in considering the evidence, the appeal panel will look solely at the written evidence and will not seek personal attendance. So is this how you understood that there was no power to hold oral hearings?
Yes. It seemed to us, or to me, and nobody on the panel, I think, had any other view. It was setting out that if you want to be on this panel, you will deal with it by means of paper hearings.
And then it goes on to say the panel will not be able to consider appeals against the ex gratia payment scheme itself, but only to examine the process to determine the claims within the terms of the scheme. So again, is that where your understanding of the, if I can put it this way, the jurisdiction of the appeal panel ended, i.e. if it was an appeal against the terms of the scheme, that had to be by way of judicial review rather than by appeal to the panel?
Yes, I mean, it seemed to me plain that what this meant was there are qualifying criteria for payments, and the panel can't vary those. The department has set out where it wants to pay ex gratia make ex gratia payments, where it doesn't. And I didn't think we could just say, well, we don't like that. We won't have a natural clearer rule, or we won't have a. Well, that's one example.
And then it goes on to set out what the test is that the appeal panel will be applying. Appeals may be made against decisions concerning both Stage 1 and Stage 2 payments. For Stage 1 appeals, the panel will need to determine whether, on the balance of probabilities, chronic hepatitis C infection resulted from the receipt of NHS blood or blood products. And for Stage 2 appeals, the likelihood on the information provided that the claimant has developed cirrhosis or primary liver cancer.
May I just ask a question here in respect of the first paragraph? The first sentence makes it clear that the job of the appeals panel is to reconsider cases, so that's a reconsideration. But the second sentence begins, the panel will look at how the decision was reached and examine all the available evidence or either confirm or change the Skipton Fund's decision. That sounds suspiciously like a review jurisdiction rather than a reconsideration,
Yes.
Doesn't it?
It does. I noticed that.
But you'd read it as a reconsideration.
Well, I think that may be a distinction without a difference, because the cases we were involved in, and I'm sure we'll come on to this, were nearly always, well, 2/3 at least, I think, were cases where the Skipton Fund appear to have turned down the application for the payment simply, or if not solely, very, very mainly on the basis that there was no documentation of a transfusion. So what one could say, really, we looked at it and we said, yet again, they've refused this applicant because there is no record of his or her transfusion. So I don't think, well, I certainly agree, Sir Brian, that there are different appeal criteria, if you like. But in practice, I don't think the second sentence really added very much to the first.
Well, it's certainly not the way you went about it, is it? From your witness statement. So that's it. As you say, it probably doesn't matter, but it's just it's a curious bit of drafting, possibly.
Certainly, I think. I mean, we looked at the Skipton file, which was generally, this is not meant at all critically, a pretty modest file. There wasn't very much in it, and we would see a letter which said, "Very sorry, but there's no evidence that you've had a transfusion rejected."
Yes.
And no doubt we'll come on to our approach. We thought we had to do a bit more than that.
Yes. Yes, thank you very much.
Excuse me.
So turning to the second paragraph under the terms of reference, which sets out the test under Stage 1 and Stage 2, it's pretty clear there that the test for Stage 1 is on the balance of probabilities because it says so. How did you understand the test for Stage 2? Because it says you must determine the likelihood. How did you understand and interpret that?
Stage 2 cases were many fewer than Stage 1 cases, and very sadly, the preponderance of the Stage 2 cases were simply a question of how far liver disease had developed. So, in the standard case, has somebody got cirrhosis or not, for example, with help from the hepatologist member of the panel, we could say, well, this person clearly has liver disease. Our view is it hasn't yet got to the stage of cirrhosis, but I'm afraid to say it's likely that it will turn into cirrhosis. So what we did in those cases was to say, in effect, not yet, but please apply again when the formulae which were accepted by the hepatitis community showed that we had got to the stage where clinically a description of or a diagnosis of cirrhosis was appropriate.
And I'll come on.
There weren't the same sort of difficulties attached to that.
I'll come on.
There were much more diagnostic questions.
I'll come on to ask you some questions about what that criteria were in due course. But am I to understand that the balance of probabilities was the test applied to likelihood for Stage 2 applications as well? So on the balance of probabilities whether or not the claimant has developed cirrhosis or primary liver cancer.
Sorry if I repeat myself, but I don't think it worked in quite the same way. On a stage 2 appeal, there would be formulae on the application form, and I'm afraid I can't remember the details, but it would be measurement. I know that one of the enzymes was ALT, and I can't remember the abbreviation of the other, but there was a set formula which was, I think, accepted by all concerned, that once one passes a certain level, there is cirrhosis, and before that there may be fibrosis, but it hasn't yet got to the stage where clinicians would say this is cirrhosis. But in most cases, sadly, those who got that sort of liver disease progressed to cirrhosis, and at that stage the papers came back to us and we said yes, there is a diagnosis which we're happy to accept, and there will be a state we allow the appeal. So it was a completely different process from stage 1.
So it was effectively a yes or no to the diagnosis?
On the basis of, if you like, laboratory measurements, yes.
Then the document goes on to the constitution of the appeals panel and sets out who will be on it. Are you able to assist us with the last paragraph there? Arrangements will be put in place for the appeals panel to take additional expert hepatological advice to review the evidence in favour of cirrhosis where claims for the second payment have been turned down, should this prove necessary. Do you understand what that was referring to? Is that something that ever happened, that you got additional expert advice?
No, I'd never seen before, but in the papers I was sent to prepare for this hearing, there was an earlier sort of draft of arrangements for appeals, and that had a pool of 5 hepatologists who would do the research and then presumably serve up an opinion or a consensus to us. But that never happened. There was never a pool of anybody else to help. It was simply the members of the panel.
Can we go then, Seamus, on to page 7 of this document? It sets out what the role of the panel chairs and members are. There's a collective responsibility for the operation of the appeals panel and requirement to engage fully in collective consideration of each case, taking account of information, etc., including the substance and principles of the scheme. Were you given any information other than what's in this document as to what the substance and principles of the scheme were that you were supposed to be taking into account?
I can't remember when we got this document, but the only thing that could possibly have qualified, I think, would be the formality of the agency agreement, which, as I think we've agreed, we got in about, well, sometime after it was finally signed, which I think was the middle of 2007.
And then to reach fair
with nothing else.
And then reach fair and considered decisions in what can be difficult situations, engage in collective consideration of each case, take account of information available, etc., and act within the appeal panel's remit. And then communications, panel members will not communicate directly with claimants, their caring physicians, or any physicians involved with their applications. Administrative tasks will be carried out by the Skipton Fund, who will present appeals for consideration by the appeals panel, and the appeals panel will submit its decisions directly to the Skipton Fund, who will be obliged to accept those decisions. Should panel members require any further information about the case when considering an appeal, it should be requested on behalf of the panel by the Skipton Fund. Was that procedure, that no direct communication between the appeal panel and the appellant, physicians, etc., was that something that happened in practice?
Strictly, yes. And I think while we're at it, the sentence about the communication of decisions maybe answers Sir Brian's question earlier. That's why we sent the decision which I wrote to the fund for Nick Fisher, one of his colleagues, to send out to the appellant. I suppose I should add one small qualification. There were several cases where Dr. Mutimer was the clinician, but we dealt with that, of course, by excluding him from the discussion. We didn't ask him to make any comments about the case in advance of the meeting that members did circulate, and he played no part in the decision making. And in case I forget later, there's one case which we turned down where one of the reasons was that there was a discrepancy between two places where the appellant said she had had the transfusion, and one of them was Roehampton. Well, that must have meant Queen Mary's Roehampton, and by a historical quirk, that was owned by and under the jurisdiction of Wandsworth Primary Care Trust, of which I was the vice chair. So I absented myself. I mean, this was all historic, long time before I was involved with the Primary Care Trust. But from an abundance of caution, I didn't play any part in that decision.
Would it have been helpful, do you think, to have had more information from the Department of Health about the terms of the scheme and the appeal panel and how they were expecting you to run it, or did you have sufficient for your purposes?
Well, in a sense, we did. What was surprising to me was so little information. But by a year in, we had the agency agreement, which formalised what we had been told fairly informally in the application form and a note on the panel that we're looking at. And what we took from it was that we didn't have paper hearings and we used the balanced probability test. It's fair to say that the involvement of the Department of Health with the panel was non-existent, except for the one meeting in 2011, I think, about the co-infected, changing the criteria for them. And I suppose that was because the Skipton Fund were their agents. I don't know, but we had no relationship at all with the Department of Health.
So
we were left to get on with it. That was the truth of it. There was a big backlog built up, and we were expected to try to get on and decide the cases, the appeals.
that was my next series of questions. Was what, if any, contact was there between the appeal panel and the Department of Health? And you said there was none at all, apart from the one meeting you've mentioned in your witness statement, which I think you say in your witness statement took place in January 2013, which I'll come on to ask you about. But that was the only direct contact that the appeal panel had with the Department of Health.
Yes. I mean, we were appointed, the members were appointed for 3 years, and I think on occasions I had to sort of send an email to Nick Fish and say, our terms are coming up. What are you going to do about it? So I think the truth was that the Department of Health was very busy. After a while, the Lansley reforms were going on, and the huge amounts of their resources, as I understand it, were being transferred to NHS England. And I think the last thing on their minds was our appeal panel.
And was...
If I'm wrong, there was no evidence to show that they were very interested in what we were doing. I mean, I think they thought it's a problem which we have, in some sense, resolved by appointing an appeal panel, and they're getting on with it, and nobody has raised any major objections. As you sent me sheaves of Skipton Fund directors' meetings and AGMs that, of course, had nothing to do with us. But occasionally I would see they would say the fund's quite happy with the way the panel's going on, and maybe that was the way the department used its agents to satisfy itself of what was going on. But all of this is outside my direct knowledge.
Was any information from the Department of Health ever fed back to you through the Skipton Fund?
Well, only, I suppose, when they changed the qualifying criteria. I can't think of anything else.
So all the changes to the qualifying criteria came through the Skipton Fund?
Well, I think so. I honestly can't remember whether... I mean, there might have been Department of Health press releases or communications to the hepatology community. But I mean, I think the case is that we were informed by the fund that the agreement had been varied. I think that's right, but I honestly can't remember the detail of it, I'm afraid.
So before I come on and ask you some questions about the relationship between the appeal panel and the fund, just turn to the meeting in January 2013. Your witness statement tells us that this arose as a result of changes made to the scheme criteria in 2011, allowing the estates of those who had died before the 29th of August 2003 to apply to the scheme. And the panel was therefore being asked to consider some cases of people with haemophilia who were co-infected and had died prior to 29th of August 2003, where the record of the main cause of death was HIV and there had been no biopsy or post-mortem examination to establish cirrhosis. Is that right?
It is right. I mean, the way I remember it is that David Mutimer, and this is shortly before he retired from the panel, he was very concerned indeed about this because he thought it almost certain, very highly probable, way more than one would need to convince the panel to allow an appeal, that anybody who had who had HIV and who had a clotting disorder would almost certainly have also had hepatitis C and cirrhosis by reason of their co-infection. And the question was how fast the co-infection increased the chances of cirrhosis. That was the basis of it. So he thought that a logical application of the new rules was that almost everybody who was in the category you just read out would in fact, although there was no evidence of it, have had chronic hepatitis C and almost certainly cirrhosis. So there was David developed a model, and I can't remember the detail. It was very highly technical, and I understood it in lay terms of what it was all about. I didn't understand the equations. And he had a view, an expert view, about how quickly the fact of co-infection worked on the chances of cirrhosis being wasn't identifiable because the person was dead, but the fact that they would, by the time of their death, had cirrhosis. And the meeting was with the Department of Health was simply to try and agree the formula of how fast the co-infection brought about the cirrhosis. And it happens, the only time I've met him, Howard Thomas, who we inquiry heard from yesterday, he appeared, I think, but I'm not sure, it was before he was the director of the Skipton Fund, but he was a world expert on hepatitis C, and he was at that meeting. By the time of the meeting, David Mutimer had retired and Professor Peter Mills had taken his place on the appeals panel. And I think it's certain that Howard Thomas's view that of the speed of co-infection causing cirrhosis was less, I wouldn't say extreme, what's the right word, was less dynamic than David Mutimer's. In other words, that Howard Thomas, and I think Peter Mills probably agreed with him, thought that the speed of development wasn't as fast as David Mutimer's formula suggested. Anyway, that was the one contact we had with the Department of Health. I think the civil servant was Ben Cole. I know that the senior person was Ailsa Wright, who used occasionally to write and say, "You've been reappointed, thank you for what you're doing." But that's the only contact I had with her. And we went to this meeting at the Department of Health. Dr. Hewitt was with us, and I can't remember who else. Oh, Nick Fish was, and maybe the chair of the Skipton Fund.
Why, if Professor Mutimer had a view that this cohort would, in fact, have had cirrhosis, did the appeal panel feel it necessary to refer the question for agreement with the Department of Health?
Because this was all completely hypothetical. And we were told, I can't remember the detail of the change of qualifying criteria, but David Mutimer said, in a sense, here's one way of looking at it, and that's a very good question, going to think about it. I think we thought that given this was an entirely controversial subject, and that there were no measurements, these people had died without any biopsies and without any test results. And David simply suggested a model. Now, one could say, I suppose, that we should have just said, all right, that's David Musman's model, we will use it. And I'm not sure I can do better than that. I thought that the appropriate thing to do was to say, was this the department's intention? That yes, that's how we approach it. We said that because I think when David Musman first introduced the subject at one of our meetings or by an email beforehand, he said, I wonder if this is what they meant to happen. Because on a literal application of this wording, those without measurements, without biopsies, would appear, in some cases at least, to be entitled to a further payment. Is that what they meant to happen? So I think we took the view that we ought to check that. And once we'd done that, of course, then there were questions of what's the correct speed of infection. It was an exponential, I remember that. There's no doubt that there was an exponential increase in likelihood of cirrhosis. And we wanted to know, given that we had no witnesses, but only hypotheses, we wanted to know what was the right approach, if you like, in terms of a scientific inquiry.
Do you recall what the outcome of that meeting was?
The outcome was that there was a reply, as I understand it, from the department. Again, a highly technical reply, which no doubt will have had, I don't know how much, whether it was Professor Thomas who was behind it or anybody else at or employed by the department. But there was a formula that they suggested. Now, I do remember, because I know that when we come on to the Ramsey report, there's a suggestion that I made a suggestion. No, there isn't a suggestion. It's a fact that I made a suggestion to Nick Fish that they rely upon the report. And I can see the force of the suggestion that I shouldn't have done that, which I accept. But on the other hand, I found in the documents that when the Department of Health gave their view on the matter, Skipton Fund, no doubt through Professor Thomas, developed its own formula for the speed of development of cirrhosis. And Nick sent me an email saying, this is what we're going to use, do you agree? And on this occasion, I wrote back to him and said, it's not a question for me to agree. You develop your criteria, we will apply our criteria. Otherwise, the appeal would have very little effect.
In effect, otherwise the appeal wouldn't be independent from the Skipton Fund and the Department of Health's decision making.
If we had said, yeah, we'll all sign up to the same agreement.
So
what happened in practice, I mean, just to be clear about it, was that this whole thing arose as a big controversy, if you like, a big scientific controversy. But we had almost no appeals because I think nearly all the people who applied were satisfied with the fund's decision. So the cases just didn't come to us. So in one sense, it was academic because we had all. I think, I'm sorry to keep interrupting you. I think in the end, we had slightly more generous, if you like, criteria in our formula than the Skipton Fund. But nobody appealed, and therefore it must have been that the fund's criterion was adequate for the appeals to be for the applications to be granted. This is all surmised.
So is this right, that having gone to the Department of Health saying, is this what you meant, when they then, in response after the meeting, said, well, this is the criteria by which we say somebody should be awarded a stage 2 payment, the appeal panel effectively said, well, we need to be independent, so you go your own way, we'll do our own thing, and we'll see where we go.
I think there's another stage. I think the outcome was the department said, yes, we can see that must be the logical consequence of the way we've changed the criteria. And then the fund, no doubt highly influenced by Professor Thomas, used a formula. We used a formula, and but we hardly ever used the formula because there were almost no appeals. There may even have been 0 appeals because the applicants were satisfied with the fund's decision, which must have been to accept the application.
I'm going to ask you now some questions about the relationship between the Skipton Fund and the appeal panel, and we've touched on some of these issues already.
Well, just before you do that, I've just, as I've listened to you talking, the appeals panel was set up to look at the evidence, all the materials. It's entirely practical and sensible for one member of the appeal panel to say, this is my experience, this is my view. In essence, I suppose, providing evidence to the panel. Nobody ever thought of that as a conflict, I take it.
Do you mean that because David Mutimer gave a view about it?
Well, he would have a view, but he was providing essentially evidence that this is what happens, this is what my experience is, this is, if you like, the expert evidence I'm giving to the panel. That's one way of looking at it. I mean, this is a tribunal of sorts.
Yes, I know, a very unusual one in my experience, because it was picked, I imagine, because there were technical questions about these applications and these appeals, which required expertise from a hepatologist and a haematologist. Now, we've seen that, or I've said that in the documents is a draft for the working of the appeals panel, which suggests there should be a pool of consultant haematologists to give evidence, but there wasn't.
Yes, so in essence, the scheme was set up to rely upon the evidence, if you like, or the expert view, the expert evidence, the opinion of the hepatologist on the panel.
Yes, in a sense, the view, the technical view, was clearly highly influential, because by definition, that particular member had a greater knowledge of the subject than the rest of us, and it would be. It could sometimes be the GP. I sometimes might have to give a legal opinion, but I think what we tried to do was treating each other as much as we could as equals. We would ask David, what does this mean, or what are the likely consequences of this measurement, and he would give his opinion, or Patricia Hewitt would give her opinion about something to do with blood, and we would take that into account, and then we would then discuss it. So there's no doubt that on matters of hepatology, David Mutimer, followed by Peter Mills, had more than 20% of the input into the question. But we didn't automatically say David says, therefore we agree.
Yes, I thought
it was not perfect. I mean, I'm certainly not suggesting for a second that this was an ideal way of going about things, but it seemed to be the set of rules that the department had put in place.
Yes. Thank you very much.
Moving on to relationships with the Skipton Fund, you obviously had a relationship with Mr. Fish, who was providing the secretariat to the appeal panel. Did you have any contact with anyone else from the Skipton Fund, any of the other directors or members of staff? Face to face,
only in the early years when I used to go, when it was time for a meeting, or a month or so before it was time for a meeting, I used to go to the fund to read the files which were coming up for appeal, to identify, to the extent I could, what further material we would like to see to make our decision easier. And on occasion, I would meet Peter Stevens, and we would have a sort of polite chat. I had completely forgotten that he wrote to me asking me to intervene with the department on the question of natural clearers until I was sent the papers for this exercise, and I didn't reply to that. I remember, to be honest, being slightly embarrassed because I could never remember which was Peter Stevens and which was Martin somebody else, who I think might be the chief executive. So I used to, hope they would say, "Hello, it's Martin," or "Oh, nice to meet you again." but there was absolutely minimal contact. And at board level, no. And we didn't get their minutes. First time I've seen their minutes, and I didn't read all of them because most of it had nothing to do with the evidence I could give to you. Was when I got the massive bundle of them for this exercise.
And do you know whether any of the medical members of the panel had discussions with medical directors of Skipton Fund?
Well, we know just from the papers I've been sent that Patricia Hewitt offered an opinion about the possible infectivity of UK anti-D product. And I've seen somewhere in the bundle towards the end an email exchange between David Mutimer and I think Nick Fish, certainly with somebody at the fund. But there were we didn't have some joint meetings every year or anything like that. There was no institutional contact.
And you say in your statement that you attended meetings at the Skipton Fund when occasion demanded, certainly no more than once a year.
That's a gross overestimate.
Can you give us an idea of what kind of meetings those would have been?
Looking back at it, I don't actually think I had any, except to the extent that when I went there to read files, if Peter Stevens was there, he might say, let's have a chat. And he used to say, how's it going? And I said, we're doing our best, sort of thing. I know on one occasion he said, Nick, why don't we invite Mark to the Christmas lunch? But they never did, and I wouldn't have gone. So, but I didn't want to be rude.
So you don't think, in fact, that there were any sort of kind of formal meetings where the Skipton Appeal Panel and the Skipton Fund got together and discussed matters?
I'm certain there weren't.
What information, we know from your previous evidence and indeed from looking at the files that the Skipton Fund, or Nick Fish, Mr. Fish anyway, as the administrator, received the Skipton Appeal Panel decision letters. Was any other material or information provided by the Skipton Appeal Panel to the Skipton Fund about the decisions that it had reached?
I can't think of any. Do you have something particular in mind?
No. It's an open question.
As far as I remember, I would write, if necessary, to him saying, we can't, well, at the end of each meeting, almost without exception, there'd be cases where we felt we just didn't have enough evidence to make a decision. So I would ask him, aside from the decision letters, I would say, look, on these cases, we need the following information. Excuse me. But apart from that, I can't think of anything.
The inquiry's seen minutes, and indeed they were sent to you, and I don't know whether you read them. It doesn't matter for the purposes of this question, but seen minutes of the Skipton Fund meeting minutes, in which Peter Stevens has asked Mr. Fish to seek further clarification from the Skipton Appeal Panel as to how they reached a certain decision. Do you recall such requests being made of you for further clarification from the Skipton Fund?
Now you say it, Nick Fish was very scrupulous, and I'm sure if he was asked to do that, he would have written. I don't remember the occasion or the occasions. I don't remember what sort of questions they were. Generally speaking, we didn't feel that we ought to account to the fund. It's perhaps also to say that it went the other way round, that if we had accepted or refused all the appeals, we would not have thought that they had any business or jurisdiction to say, well, that's not right, and equally, we had no targets, we had no budgets, we dealt with every case as it were. And if I'd been asked, suppose I was asked, why did you decide that? I don't think I would have chosen to add to the decision on the basis that we were told that in the initial paperwork that you've looked at this morning, that the decision of the appeals panel was final.
Can we look at an email thread? It's at NHBT 20912224_007. This is an email thread between well, it starts off with an email from yourself to Mr. Fish, and then so this is the end of the email thread on the 18th of August 2011. So if we can start on the last page, page 4, please. So about halfway down the page is the first email on the 9th of August. It says, Nick, the haemophilia cases have made us think again about the scheme. Is the proper criterion simply treatment with blood or blood products in an NHS clinic, or must that treatment also be with NHS blood or blood products? And then it says, in cases involving haemophilia, it would be very useful to know whether the haemophilia was mild or severe, whether the treatment was restricted to cryoprecipitate. If it was not, as much evidence as possible should be provided to show whether the clotting factors included commercial concentrates or were restricted to NHS product. I look forward to hearing from you in due course. So that's the beginning of the email trail, and we'll look at where it goes in a moment. But why was it that you were asking the Skipton Fund or inviting the Skipton Fund to collaborate on the approach to the scheme?
I had forgotten all about this, and I can't, I'm afraid, give you a very good answer. I think what prompted it was when we came on to, it was a very long time, as I remember it, before we got any cases where the appellant had a clotting disorder. And maybe this is me sort of with a throwback to the HIV haemophilia litigation. And I suddenly think, am I being silly here? Does NHS blood or blood product mean manufactured by or provided by? That's where it all started. In other words, is the criterion that you are paid if anything you get is provided through the NHS, or in the case of haemophilia, do you only get paid if factor 8 is NHS factor 8 and not commercial concentrate? That's where it all started. And the I suppose more direct answer to your question is that as they were the agents of the Department of Health, my wording is sloppy, and what I'm doing is I'm asking the fund as agents to provide a view from the department. I accept that is what the email says, but that would have been why we sent it to them.
And why then would it be appropriate for the appeal panel to seek clarification or guidance from the Department of Health on an issue of the interpretation of the scheme?
Well, because their intention would have at least been informative, if not binding on us. I mean, I can't remember now, and I'm sure we're not going to look at the agency agreement, but I can't remember whether NHS blood or blood products was defined in the agency agreement as anything that was given to a patient in an NHS setting or anything that was made by the NHS. The whole thing was, in retrospect, and as I say, I had no recollection of this at all till I saw it in the bundle, where it was a complete red herring.
Do you think taking this kind of approach of asking for clarification, going to the Department of Health, asking for their view or their guidance on how matters should be interpreted, do you think that impugned the independence of the appeal panel?
Well, if so, to an extremely small extent. This is the agency agreement is the only formal document that we have that governs our business. And I think it would have been important, but it turned out to be a complete red herring, to check that people were entitled if their infection came from treatment in an NHS facility rather than treatment with a product that the NHS had made. I don't think I can say any different to that. I perfectly accept that we could have taken an independent view without asking the fund on behalf of the department or the department direct, but that's what we did. I can't change that.
Having said, I'm going to look at other the rest of those emails. In fact, I don't think it's necessary for the purpose of that question. So, Shomit, you can take that document down. You've already mentioned the email that you sent to Mr. Fish, suggesting that the Skipton Fund should use a particular report when dealing with applications about intravenous drug use. And you've said in your witness statement that you think, with the benefit of hindsight, that that was an error. Can you just explain to us why you think that that was an error to have made that request of the Skipton Fund?
It was a suggestion, not a request. Because as with the criteria for co-infection, it was for them to develop their formula and for us to develop our formula. We had got something. I think I said in my witness statement that it seemed to us that where there was a paper by, we were told, the leading authority in the UK about infection from intravenous drug use and infection from blood transfusions. We thought they were objective, quantitative, derived from peer-reviewed journal evidence that was in one sense objective, and we thought it would be a shame if somebody had been turned down on non-quantitative grounds, if you like, had appealed to us, and we'd say, well, there's a piece of paper that proves that it's wrong. I accept I shouldn't have done it, and I learnt the folly of my ways by the time I told Nick Fish that they should use their formula for co-infection and we would use ours.
I'm going to ask you some questions now about the procedure, and we've touched on some of this already, and you've explained to us that you, is this right, that you were provided with the appeal papers by Mr. Fish?
Yes.
And were those all the papers that the Skipton Fund had? In other words, there wasn't a cohort of papers that the Skipton Fund saw that the appeal panel never saw?
Well, I couldn't possibly answer that, could I?
But as far as you were aware?
I understood we were provided with complete files, yes. but what else was in Skipton's office, I wouldn't know. I can't see any reason why we wouldn't have done. I assumed that we did have complete files.
And you've explained how in the early days you would attend the office to decide whether any further information was required prior to the hearing of the appeal. What happened latterly? There's an inference that you stopped attending the office to carry out that task. So how was that task performed latterly?
We will get the papers and in advance of the meeting. And of course, when I went to look at the files, I could only, if it was something which would have been very helpful, but some laboratory test results that I just wouldn't, as a lawyer, have known existed or should exist, or what they might mean, or whether they were complete, etc. So I was really saying, in cases where there was minimal information, well, could you please at least ask them to provide such and such? But there would also be cases where one of the, if I can call them technical members of the appeals panel, would say, either before or at the meeting, the records end here, but they should go on to there. We can't really make a fair decision without seeing the rest of it, in which case the case would be adjourned or deferred, and we would ask for more.
And we know from what you've already told us that all requests for further information would have gone via Mr. Fish. Would he make requests for further information off his own back, or would they always have to be directed by the appeal panel?
Well, again, I mean, I can't really answer that question, but I heard at the end of Professor Thomas's evidence yesterday, the very end of it, and he talked about seeking out information. But I think, again, I don't want to trespass on the Skipton Fund's territory, but it looked as if they started off with Nick Fish and I think Mrs. Boyd, or Dr. Boyd, I can't remember her status, making a decision. And then towards the end, because we were making different decisions so often on the basis of getting more information and making inferences. I think they enlisted, well, I know they enlisted Professor Thomas and Professor Dusheko to make the similar sorts of inferential decisions that the appeal panel made. That's a long way of saying, Professor Thomas himself said yesterday, we would ask for information like photographs of a scar. So I suspect the Skipton Fund's process and procedures changed when they got medically qualified directors employed to look at files on board. But that really is a question for the fund.
So I don't think I made my question specific enough. I meant in relation to the appeal process. So would Mr. Fish, as performing the role as secretariat to the appeal panel, make requests for further information himself, or would those requests always have to come through somebody on the appeal panel?
Well, in the papers is our guidance notes, are our guidance notes for appellants, and that would set out what would help us make a more informed decision. And it seems from the files that we've seen that this was routinely sent out by the fund to people when they said they wanted to appeal.
I'll look at that in a moment. Just sticking with the procedure, then, is this right from your witness statement? You tell us there were no time limits for appeals.
Yes.
There were no fees payable for appeals.
No.
And there was no application form that had to be completed for an appeal.
No, that's right.
So
I'm sorry to interrupt you, but it was also the case that we didn't say, right, you've appealed, that's it. You could come, if there's more information, come back to us and we'll look again.
Should we look then at the guidance provided to appellants? Then it's NHBT 209 0738. Was this a document that you wrote? Can you recall?
Well, there are different versions of this document in the papers, and I know that it was expanded, and I got this wrong, I think I misremembered in my witness statement after or around the time of the judicial review. And I think, if I remember rightly, and we've got in my bundles, if we need it, we've got the different versions. I don't know yet, because I can't see the end of it, whether this is the final version, but as I described in the witness statement, because all the difficult cases in our initial few meetings were cases where there wasn't any documentation of a transfusion. It wasn't an argument about whether or not the case was outside the parameters of the scheme, if you like. There were cases where the appellant said, I had one, and there was no indication in the notes, medical records, or in the file that they did. So we thought, we're never going to resolve this for certain, but helping to allow us to make better decisions would be a list of things that would help us in our decisions, and some sort of explanation of the way we went about it.
And so you have there, under missing records, you set out some steps that appellants can take in order to find their records,
Yes.
Including going to the GP and obtaining, if records aren't available, obtaining a letter to that effect from the relevant NHS body. Did the Skipton Appeal Panel provide any direct assistance to appellants in tracking medical records down? In other words, would they do no? And did you ever come across an appellant who could not afford the cost of copying or producing medical records?
We were never told that was the case, and I suppose, perhaps naively, I assumed that wouldn't be a cost to the appellant. Or I vaguely remember from my days of practice and perhaps one of the tribunals I sat on that there was a small fixed fee, which I think to begin with was £10. But the honest answer is we never had that experience of somebody saying, I can't do this because I can't afford it. And to be honest, we didn't think about it.
And then you set out at paragraphs 5 to 7 the direct first-hand evidence that the appellant can provide, a personal statement, paragraph 5, 6, paragraph 6, any statements from witnesses, and then paragraph 7, written evidence about treatment that they have, I believe, led to the infection. Were you aware that the Skipton Fund had not been able to consider any of this kind of evidence? All they had considered at the first stage was the form as it had been filled out by the clinician.
I don't think I wasn't specifically aware of that. What I was aware from looking at the files was that most of the cases we got to deal with were cases where no documentation of transfusion equals no explanation of payment, which may be an answer to your question, meaning yes, that's what happened. But I mean, we didn't intervene in the Skipton Fund's decision making.
And then paragraph 8, in the absence of complete records, the panel will make a judgment on the likelihood of your exposure to hepatitis C, given the type of treatment, the circumstances and the outcome that you describe. Is that what you refer to in your witness statement as clinical plausibility?
Yes, in effect.
And I'll come back and ask some questions about that. And then over the page, there's some paragraphs on IVDU. Applicants who have had a history of exposure to recreational intravenous drug use, such as heroin, are unlikely to succeed in their appeal. And then there's a reference to the expert report or the expert advice. However, because the panel considers each case individually, you should document all your intravenous drug use in as much detail as you can, and then the panel will make a judgment on the relative likelihood of your having obtained hepatitis C from IVDU or from NHS treatment. Again, I'll come back to ask you some questions in relation to that, but certainly this suggests that IVDU isn't the end of the application. There is an assessment that is carried out. Is that right?
Yes, that would have to be the right approach, wouldn't it?
And then at the bottom of the page, then sets out what other risk factors are, other reasons for refusal, and then at paragraph 3 at the bottom, it says fluid replacement, artificial plasma expanders, and intramuscular anti-D immunisation in pregnancy and miscarriage abortion are not associated with hepatitis C infection and will not be considered by the panel as probable causes of your infection. So is it right to understand that if the history was infection via anti-D, that was a no, that was a strike, there was no balancing and consideration of the evidence?
Well, that's slightly too simple, if I may say so, because if somebody had had anti-D, which was manufactured in Germany or the Republic of Ireland, then there was a distinct possibility that that product would be infected. But perhaps we should have said NHS produced anti-D immunisation. And I know I've heard questions to Mr. Fish, and I've heard Council's presentation about anti-D, and no doubt you'll ask me about it, and no doubt you'll ask Dr. Hewitt about it.
I will come back to that. I think you've said that there were different iterations of this guidance, and
yes,
we're not entirely sure which iteration this was. But
sorry, if that's the end of it, it's an early one.
Well, it does. There's another page. If we go over to the next page, it says obtain a copy of your original application form. Make sure you agree with your consultant, and then the last paragraph is on natural clearers and explaining the position in relation to them.
I think that means that's the later version, that long paragraph on natural clearers. But the last one was longer than the first one. I know that. So you could compare possibly the two documents in the bundle.
But whichever iteration was in place at the time, this was the information and guidance and assistance that the appellant would have received from the appeal panel.
Yes.
One of the features of the scheme was that there was no, the clinicians filling out the application form couldn't charge a fee, or at least if they did charge a fee, Skipton Fund or the appeal panel wouldn't pay for it. Given that the clinicians were required to search, well, could be required in some cases to search back through many years of old records to find relevant entries, do you think that the quality of the evidence provided by clinicians may have been improved if payment had been made?
Well, with respect, I don't think that's a question for the panel. Surely a question for the fund, isn't it? We had no relation with the doctors. We simply had a file of papers delivered, read them carefully and discussed them and made a decision. The problem, I think, the problem as I understand it was the long lapse of time leading to the destruction of records under NHS policies. So I know from other tribunals that there's an evidence gathering stage, normally done by the office, where the relevant NHS body is asked or ordered to produce somebody's records. So I don't think it's a question of the consultant trawling through records to try and find a clue. I think that's something that the fund would have done or we would have done. I think the problem was, as I understood it, that the clinician had to give an opinion about whether or not somebody had been given a blood transfusion which had infected the appellant with HCV, not that the consultant was being asked to do a very onerous search of large files. The problem was the lack of documents, not the burden of going through them.
And the aim, as I understand it from your witness statement, was to have all 5 members of the panel present at every meeting. Is that right?
Yes.
We know from your previous evidence that all hearings were conducted on the papers. There were no oral hearings at all.
Yes.
Is that something that you ever considered to be an impediment in your decision making?
Well, I think I've said in my witness statement, if the questions either of credibility or memory or quality of evidence or even looking for scars that weren't operation scars in photographs, I have no doubt that with representation, submissions, cross-examination, I have no doubt we could have given more informed decisions. But the Department of Health set up a system. We applied to be appointed. We were appointed. We worked by the system, like rules of court, in effect. Of course, I'm not saying that this was the best system of justice available. I'm saying that this was within the rules that have been set by the department. We did the best we could.
And you've explained in your witness statement that the panel would meet approximately quarterly.
Yeah.
Is that right? Did the panel keep any records of their decisions or any minutes of meetings or anything of that sort?
I kept notes of the discussion, and at the end in 2017, because remember that this is all being done from my home, I have hidden in my home some extraordinarily sensitive documents about 443 individuals. I said to Nick Fish, I really don't want to keep these, I shouldn't keep these, and they were sent back to the fund. We didn't publish notes of our discussions, we didn't publish minutes of the decision-making process. And I fully accept, which I'm sure we'll come on to, that there was a question about the form of the decision letters. But I mean, no, we didn't keep formal minutes.
So I note the time. I've still got a few more questions on the procedure itself. I don't know whether it would be sensible to finish those before we break or whether we should break now.
Well, how long will they take?
They shouldn't take very long. 10 minutes, perhaps.
Okay. Well, let's proceed.
You've described in your witness statement that you would discuss each case on the agenda in turn and come to a determination with your fellow panel members, and you would seek for unanimity. And if you couldn't get that, there would be a majority vote. Is that right?
It's right. It was extremely rare that it came to that. Very rare indeed.
And your options were effectively uphold the Skipton Fund's decision, overturn the Skipton Fund's decision, or send the matter back because you needed more information and you weren't in a position to make a determination.
Well, yes, I would express the third as ask for more information.
And then you've explained to us that you drafted the reasons following the decisions made by the panel. Was it necessary for the panel to agree on the reasons, or was that left to you, your discretion?
I don't know how far you want to get into the decision writing process now, because the answer varies on what the decision was.
Just that it's the process rather than that I'm interested in.
As I said in my witness statement, if it were clear what the decision was, excuse me, and the reasons for it, then I would write. I would, at the end of the discussion, I would say, right, this is what I'm going to say. Is that right? And people would say yes or no, and then I would send it. In some cases where there were technical matters, I would, and this is probably 1 in 30 decisions, I would send if it were a hepatology query, to the hepatologist, if blood, to Dr. Hewitt. I would say, here's a draft of my letter, have I got this bit right?
Where there was a split in the vote, if I can put it that way, was that something that was ever relayed to the appellant?
No, because it was very rare indeed that people, whether it was because, in a sense, I think we trusted each other and we deferred to each other on matters technical. I think if there were a real weight of opinion one way, it would be very, very unusual for one person to, as it were, register a minority opinion requiring a vote.
We've seen the inquiry's seen a range of decision letters, and is this fair that when the decision was to overturn the appeal, that the reasons were generally rather shorter, but when the decision was to effectively reject the appeal, they went into somewhat more detail? Would that be fair?
That's absolutely right, but it was more than that. I don't know whether you want me to get into the whole subject of decision writing now, but in effect, when I first met Nick Fish at the fund, I said was the effect of what is the fund looking for in terms of a decision? Do you want a judgment? Do you want a letter? And he said, and you may say I shouldn't have accepted this, he said a letter, keeping it as brief and simple as you can. And I don't know whether at that stage or subsequently I said, well, what if we are allowing the appeal? Do you want us to go into reasons? Does the fund want reasons? Or shall we just say we're satisfied that you qualify? And to the best of my recollection, and you might want to ask Nick Fish whether he remembers the same, I think it was agreed that a simple decision saying you've been successful would be enough. There's of course a question about whether or not we should have produced more formal judgments, and no doubt we'll come on to that, but that was what happened. So yes, if you succeeded, you were just told, in effect, good news, you've succeeded.
And just finally then on the procedure, you've told us a little bit about the role of that the medical members of the panel took in advising the panel as to medical matters within their own expertise. What was the position, or did this ever arise, where you were faced with a medical question that was out with the expertise of all of those on the panel? Were you able to, or did you ever seek further input from clinicians?
I didn't. And as I said in my witness statement, I'm sure that medical members would have looked at old medical textbooks if they needed to, might have consulted older colleagues if it was a question of what happened in the 1950s, that sort of thing. But people came armed with whatever corpus of expertise they had or of information they had to contribute to the decision.
Do you recall instances where second-hand information, if I can put it like that, second-hand advice was being relayed to the panel from another clinician who was practicing in the 50s or perhaps practiced in a different discipline, to tell you about the likelihood of blood transfusion being used for different procedures?
Not specifically. The other thing is, I was thinking about this before we started. Dr. Drakehouse, I think the appointment letter or the press release said he was 62 in 2006. He was an immensely experienced GP and I thought had an extremely wide medical knowledge. If he was 62 in 2006, by 1965, which was I think the so generally, well certainly for the purpose of co-infection, it was the date that hepatitis C was thought to be circulating in the UK, he would have at least been a medical student, if not a doctor. Now that's a roundabout answer. I can't be certain, but we never, put it this way, we never based our decision or what swung us to yes rather than no or no rather than yes was never a relayed second-hand decision by a different clinician.
So those are the questions I wanted to ask on process, so perhaps it's now would be a good time to break.
Yes, well, we'll take a break. We normally have take half an hour, and so if you can be back here, please, at 5 minutes to 12. So 5 minutes to 12.